I've watched a lot of people walk into this courtroom believing they were the smartest person in the room, but nothing prepared me for the morning Diane Marsh sat down at that defense table, heard 38 months of deliberate financial theft read into the record, and sighed. Not nervously, not involuntarily. She sighed the way someone sighs when a meeting is running longer than it should. And when I asked her a direct question about the woman whose payroll she had nearly destroyed, not a legal question, not a procedural question, a human question, she told me calmly and precisely and to my face that the question was emotionally manipulative. What happened in the next 20 minutes proved something I have believed for 30 years on this bench. You can walk into this room wearing composure like a coat. You can have it fitted, practiced, and convincing enough to work in every other room you have ever been in, but this room sees what is underneath it. And what was underneath Diane Marsh's composure that morning was the thing that sealed every word of her sentence. If you believe that calling accountability manipulative is itself the most revealing thing a defendant can do in a courtroom, stay for every word of this story, because what I did next is exactly what this bench is built for. The file on my desk that morning described 38 months of financial misconduct across a single organization. Fraud, theft, and systematic falsification of expense records totaling $127,000. Redirected from the reimbursement accounts of 11 small business owners and independent contractors into a personal account built specifically to receive it. The methodology had been constructed to stay below every automatic audit threshold the company system contained. It had worked for 38 months. It had stopped working because one person had been doing her job carefully enough to notice a routing number that didn't belong. Diane Marsh entered the courtroom in a fitted charcoal blazer over a silk blouse, moving with the practiced composure of someone who has spent a decade in rooms where her job was to manage how things were perceived. Her posture was controlled. Her expression had been arranged with care. She took her seat at the defense table without looking at the bench, and her attorney, a well-regarded white-collar defense specialist who has appeared before this bench on 3 previous occasions, opened his document folio with the specific efficiency of someone who believes the morning will be manageable. Diane glanced at the gallery briefly without interest. She found nothing there that required her attention and looked back at the table. What she had looked past: Patricia Owens, second row, 58 years old, Director of Internal Accounts, 31 years of financial compliance work, which is 31 years of doing the kind of careful, unglamorous, detail-level work that finds things other people miss. Patricia had found this. She had spent 6 weeks building the documentation before she brought it to legal counsel. She was sitting with her hands folded and her expression completely steady. And Grace Tanner, third row, gray blazer. She had come alone. She had been waiting 7 months. Diane had not looked at either of them. She looked at this courtroom the way someone looks at a room they have already decided they know how to handle. Diane's attorney rose and presented the defense framework with the polished efficiency of someone who has spent a career learning how to make systematic financial misconduct sound like a private struggle that got out of hand. His client, he explained, had been operating under extraordinary personal financial pressure, a combination of compounding circumstances that had led over time to decisions she deeply regrets. He spoke of her 10 years of exemplary service to Hale Capital Group, her consistently positive performance reviews, the trust she had earned and maintained across a decade of professional responsibility. He noted that she had already offered full restitution and characterized the charges as an appropriate subject for a negotiated resolution. He was measured, practiced, and delivering the specific argument of someone who has learned that the most effective framing of deliberate financial misconduct is to make it sound like an overwhelmed person making a series of private mistakes rather than a systematic actor making a series of calculated decisions. I listened to every word. Then I asked my first question. Counsel, your client's offer of full restitution, when was that offer made? Following the charges being filed, he confirmed. I asked whether any restitution had been offered or any attempt at restitution made in the 7 months between the discovery of the misconduct and the filing of charges. He recalibrated. No, he said, not formally. I asked my third question. The forensic audit documents a system of constructed routing numbers, manipulated authorization timestamps, and calibrated processing intervals, built over more than 3 years. Can you help this court understand how extraordinary personal financial pressure produces that specific architecture rather than a series of discrete decisions? The attorney began a response about habitual compensatory behavior and how financial stress can produce patterns over time. I said, "Counsel, what I am describing is not a habit. What I am describing is an architecture. There is a difference." Then I asked to have the forensic audit entered into evidence. I read 3 passages aloud, not the summary, not the conclusions. The 3 passages that described in the forensic accountant's own technical language how the system had been built and how it had been operated. The first passage described the construction of the false vendor routing numbers. Each one had been registered to a shell account that processed through 2 intermediate processes before reaching its destination, a structure that created sufficient transactional distance to prevent any single-step audit from identifying the origin and the endpoint as the same person. The second passage described the authorization timestamp manipulation. Approvals had been logged during high-volume processing periods, specifically the 3 days following monthly billing cycles, when the volume of legitimate transactions through the system was highest and secondary review was statistically least likely to be triggered. The timing had been consistent across 38 months. The third passage described the processing interval calibration. Each individual transaction had been sized to remain below the threshold that would flag an automatic audit review. The intervals between transactions had been spaced to avoid pattern recognition triggers in the company's monitoring software. The calibration had been adjusted twice over the 38-month period, once when the company updated its audit threshold parameters, and once when a new expense authorization protocol was introduced. I read all 3 passages without commentary. The courtroom was quiet when I finished. I looked at Diane Marsh. Her expression had not changed. She was projecting the composure of someone listening to an account of events that are being characterized unfairly, the specific maintained expression of a person who has decided that the correct response to hearing her own methodology described in a courtroom is to communicate that the characterization is not accurate. Then she made a sound. It was a small sound. It filled the courtroom completely. I looked at Diane Marsh for a moment without speaking. Then I asked a direct question about what she had done and who she had done it to. Ms. Marsh, the woman in the 3rd row, is named Grace Tanner. She runs a 4-person event coordination firm. She completed a 6-month contract with Hale Capital Group in good faith and submitted $31,000 in documented, legitimate reimbursement expenses. While your system was processing those expenses into your own account, her firm nearly missed payroll. I want to ask you, not your attorney, not this record, whether you knew when you redirected that specific reimbursement that the money belonged to a business that employed other people. Diane's attorney placed his hand on her arm. Diane looked at his hand, then she looked at me, and she chose to speak. She said calmly, precisely, with the controlled delivery of someone who has spent a decade managing the communications of a powerful man and believes she understands how rooms work, that she would like to note, respectfully, that this line of questioning appeared to be designed to be emotionally manipulative rather than legally relevant. She said she had been told this hearing was about restitution and sentencing parameters. She said it appeared to have become something else. She said she did not think that was appropriate. The courtroom did not move. I looked at Diane Marsh for a long moment. I picked up my pen. I made a single note. I set the pen down. Then I spoke. Ms. Boak, Marsh, you have just told this court that a direct question about the human impact of your conduct is emotionally manipulative. You have sighed audibly at the reading of a forensic audit, and you have described this proceeding as a performance. I want you to understand something. You are not managing a calendar in this room. I named 3 things. Not as a list, as a record. You sighed when a forensic audit describing 38 months of deliberate financial architecture was read into evidence in a room containing 11 people whose documented losses funded the system you built. You told this court that asking you a direct question about Grace Tanner's payroll was emotionally manipulative. And you described this proceeding in which those 11 people are present or documented as having been materially harmed as a performance for the gallery. I let each of those things sit in the room for a moment before continuing. Ms. Marsh, you have spent a decade in a role where your primary function was to control access, manage information, and shape how your employer's office was perceived by the people around it. You are very good at that work. You have been doing it this morning, but I want to be precise with you about something. You are not managing a calendar in this room. You are not controlling access to information in this room. And the impression you have decided to project this morning is not the one you think it is. Diane's attorney rose and began a sentence about the nature of his client's presentation and the court's characterization of it. I looked at him. He sat down. The gallery was completely still. Patricia Owens had not moved. Grace Tanner had not moved. The room had the specific quality of stillness that comes when every person present has understood simultaneously that the proceeding has arrived at the moment it was always going to arrive at, and that nothing said in the next 60 seconds will change what the next 60 seconds contain. I turned to the sentencing file. I found Diane Marsh guilty on all counts. The sentence had 5 components, and I delivered each one with the same precision I had used to read the forensic audit. 18 months in state correctional facility, no suspended time, no early release consideration for the first 12 months. Full restitution of $127,000 to the 11 affected parties in amounts proportional to their documented losses, with payments to begin within 60 days of release and to be monitored by court-appointed financial oversight for a period of 5 years. Not self-reported, monitored. 5 years of supervised probation following release with mandatory quarterly compliance reporting to this court. A permanent bar from serving in any fiduciary, financial management, or administrative authority role for any period during which she remains on supervised probation, and a written formal apology to each of the 11 affected parties drafted by Diane Marsh, reviewed by this court for authenticity before delivery, and sent before the end of the current calendar month. Diane's attorney argued that the sentence was disproportionate for a first-time nonviolent offense with a full restitution offer already on the table. I said, "Counsel, your client built a system. She ran it for 38 months. She sighed when it was described in this courtroom, and she told me that asking her about Grace Tanner's payroll was emotionally manipulative. This sentence is not disproportionate. It is the correct response to what was actually done and to how your client has chosen to present yourself in this proceeding." Diane Marsh's composure, which had held through the entrance and the audit and the 3 named things, fractured not in genuine reckoning, but in the specific way of someone who has understood that the room did not respond to the strategy she brought into it. She said to no one in particular, "Conrad will hear about this." I said, "Mr. Hale is welcome to review the public transcript of these proceedings. So is anyone else." The bailiff moved toward the defense table. And then, from the second row, without being asked, without being invited, without any instruction from this bench, Patricia Owens stood. She stood with the quiet authority of someone who has spent 31 years doing work that requires noticing things other people miss, and who has one thing to say and intends to say it on the record. She said, "Your Honor, I want the record to reflect that what I found in that reconciliation was not an accident and not a coincidence. It was a system built by someone who understood exactly what she was doing and trusted that no one would look closely enough to find it. I looked. And I want the 11 people whose names are in that audit to know that someone looked." The courtroom was quiet. Then Grace Tanner in the 3rd row, gray blazer, 7 months of waiting folded in her lap, nodded once. A small, deliberate nod. Conrad Hale did not attend the hearing. His legal counsel submitted a written statement. 3 sentences confirming that Hale Capital Group supported the court's findings and would cooperate fully with the restitution monitoring process. The judge read it, noted it for the record, and moved on. Diane Marsh served the full 18 months. At 14 months, she became eligible for the early release review the sentence had specified would not apply for 12. The review board found her conduct during incarceration compliant. It also noted the absence of any documented engagement with the victim impact materials that had been provided to her during her sentence. The early release was not granted. The restitution payments began 62 days after her release. They were made, all of them. Grace Tanner's $31,000 arrived in 4 structured payments across the first year of the monitoring period. Grace used part of it to hire a 5th staff member. Patricia Owens retired from Hale Capital Group 18 months after the hearing. Having spent the intervening period helping the company rebuild its expense authorization system, the specific vulnerability Diane had exploited was removed, and a secondary verification layer was installed. At her retirement gathering, a colleague gave a brief speech mentioning the routine year-end reconciliation that had led to the forensic audit. Patricia said it was just the work. Doing the work carefully. That is what it always is. The written apologies were delivered before the end of the calendar month as ordered. Grace Tanner received hers, read it, and filed it. She did not frame it. She did not discard it. It was a document that had been reviewed by the court before it could be sent, which meant it contained at least the minimum of what accountability requires. That is what it was worth, she decided. She treated it as exactly that much and not less. Not the routing numbers, not the timestamps, not the transaction intervals. Those are details. The 3 passages I keep in the top drawer of my desk are the ones that, taken together, require a specific word. A word the defense framework had spent its entire presentation trying to replace with softer ones: architecture. Not a habit produced by pressure. Not a pattern that emerged from difficult circumstances. Not a series of regrettable decisions made by someone who lost her way. Something built, something that required 38 months of deliberate, sustained attention, calibrated twice when the parameters changed, adjusted when new protocols were introduced, maintained with the specific confidence of someone who believed that the distance between her access and anyone else's scrutiny was sufficient protection. It was not sufficient protection. Patricia Owens was doing the work carefully enough to find it. The sentence was built in response to the architecture. The public transcript reflects what happened. Both of those things are permanent. Patricia looked. Grace filed the apology and decided precisely what it was worth. The firm on the other side of that $31,000 now has 5 people doing work that needs to be done. That is what this bench is for. Not to negotiate with architecture, to name it, to sentence it, and to make sure the record reflects exactly what it was. I want to say something directly to everyone watching this. Diane Marsh walked into that courtroom believing that composure was management, that the right expression, the right framing, and the right characterization of a direct question as emotionally manipulative could make 38 months of deliberate financial architecture look like something a sentence could negotiate around. What she did not account for was a director of internal accounts who spent 6 weeks building documentation on her own time. Because doing a work carefully is what 31 years of careful work looks like. And a bench that looked at what was in front of it and named it not pressure, not habit, not a private mistake, but an architecture built deliberately, maintained carefully, calibrated twice when the parameters changed, sentenced accordingly. This was not about punishing ambition or financial difficulty. It was about holding a system accountable for what it was built to do. The record reflects what happened. Both of those things are permanent. Patricia Owens looked. Grace Tanner came alone to a hearing she had been waiting 7 months for and nodded once when her name was said on the record. That is what this bench exists to confirm. Share this. Subscribe. Tell someone who needs to hear it. Patricia Owens. The work done carefully. 31 years. Still here.